Good evening, everyone. It is with great pleasure to extend my warm welcome to each one of you. With my pleasure, I introduce myself. I am Kiran Taneja, practicing chartered accountant and forensic auditor. Today's one-day conference on IBC is one of a kind program where we have a very unique opportunity of gathering of top faculties, speakers with the expertise in IBC and other areas. We are truly honored and obliged to have insightful knowledge from all these speakers in the previous session. The last session of today's conference focuses on resolution of personal guarantor and effect of avoidance transaction. I would request Nipun Singhvi sir and Durgesh Pandey sir to please come on stage. Let me quickly introduce the speakers. First, we have Advocate Nipun Singhvi sir. He is qualified chartered accountant, CS, LLB, LLM, certified forensic auditor, qualified independent auditor, qualified insolvency professional. He has been appointed by NCLT for convening meetings as chairman in disputed cases of operations and mismanagement. He delivered more than 1,600 lectures on various laws across major cities. He is also awarded by Divya Bhaskar for excellent contribution in real estate justice. He is expert on corporate, commercial, and insolvency law, advised and handled more than 650 insolvency cases, including JP Infra, SRS Steel, and many more. Now he just conferred doctorate in insolvency laws. The next speaker is I would request Sunit sir to felicitate Nipun sir. The next speaker is Dr. Durgesh Pandey sir. He is chartered accountant, PhD in forensic accounting, certified fraud examiner from ACFE USA, diploma in information system. He is having more than 15 years of experience on advising clients on various areas with the exclusive practice in the domain of forensic investigation of financial crime and dispute resolution. He has conducted fraud examination in multiple countries. He has conducted training for senior bureaucrats in India for IAS officer, IPS officer, IRS officers of more than 35 countries on investigation of financial crime. Now I would request, basically this is the last session of today's conference, but I'm sure this is going to be as energetic as the previous sessions. Now I would request Nipun sir to please come forward and give his valuable. I would request Sunit sir to felicitate Durgesh sir.
Very warm good evening to all friends, seniors, colleagues. So this brings us to the last session. And Durgesh sir, I think that you can be on the dais so that we both can interact and we utilize maximum time together. Yes, Sunit sir, you also please come.
Otherwise, I should come there.
And I think that the sessions today were wonderful. We learned a lot from the experiences of so many people across country. And I would especially thank Sunit Bhai for being the architect of this, one of the best insolvency conference. When we meet people from across the country, we come to know what is going on in that part of the country. And this is very interesting. And very few friends also came from South. When I went to give a lecture there in Kerala, I learned how they were doing winding up. We were not doing winding up that time in Gujarat. When I went to Tamil Nadu, I just saw that if the non-cooperation of promoter is there, on the second date they issue the warrants. So that's how you learn. Law is same, but how you use it makes a big difference. My topic, a very interesting topic, and I think Sunit Bhai has given me this topic because one of the first cases of common repayment plan approval we had secured in Ahmedabad, and I think it's one of the first in India, where many personal guarantors gave a common repayment plan and it was approved. Approved by the COC, approved by the NCLT. And the payment has also come. That's the biggest part. As we say personal guarantors, and I've used the pic you can see, I remember we had that movie, I think Andaz Apna Apna. कभी तू छैला लगता है, कभी तू छलिया लगता है. So that's how it happens in personal guarantor. We don't know वो कितनी companies में director है. We don't know in how many partnership firms he's a partner, how many proprietorships he's running, whether he's having HUF. We don't know. And that's how the difficulty starts. And we were just jokingly discussing last night, if you go and there is a lady personal guarantor, you go at the home knocking and asking, please tell me how much jewelry you have. You know what will happen. And that's the personal guarantee. Once the personal insolvency starts, and for all the females here, you will only have an exclusion of 1 lakh. So the ornaments, the jewelries is only 1 lakh that is exempt. The rest will go to RP for process. We don't know. How that process will be conducted, it's a big challenge. But yes, this is the hard truth. And some of the interesting things which happened and which is happening, I am again going to share my experience. And Durgesh Bhai is here. He will be guiding us in what transaction we can identify that. I don't know how personal insolvency will become a success. As in the previous sessions we have discussed, whether it will be a success or a failure, we don't know. But it is going to be a very big challenge, and it is going to be a very big opportunity for all of us. Because most of the companies or the major part of NPAs have been resolved. So now personal guarantees is going to be the next big issue. And some of the issues which is cropping up day in and day out, and some of my views, how I perceive them. So one is that once an account is NPA, we all know that there is a 13(2) notice given by the bank. SARFAESI notice is there. Whether a 13(2) notice given to the guarantor of the company, so that is the personal guarantor, would amount to invocation of guarantee for the purpose of personal insolvency under IB code. So that is an issue which is now settled by NCLAT, saying that we will not consider 13(2) notice as invocation of guarantee. It is only with respect to the secured asset of the company for which there is an intimation. And it is not invocation of personal guarantee. And therefore, it cannot be used as a tool to trigger personal guarantor's insolvency. So that is the view taken by NCLT, and now there are multiple orders. And that is how bankers, and I suppose some of the bankers are also here, once you start insolvency of a corporate debtor or you file for it, make sure that you also invoke the personal guarantee and file for it. And my view is, and I have also suggested to regulators time and again, and probably now they are coming up with, there should be a combined insolvency of the company and the personal guarantor. Otherwise, the personal guarantor will keep on filing litigations so that the CIRP does not take place in a smooth manner. And it's a classic case where land will always belong to the promoter and the building will always belong to the company. That's always there. Car payment will be from the CD's account, but the RTO registration will be in the name of individual. So these are the classic cases which we have seen in all these 7 years, where multiple guarantees, multiple securities, and no resolution because of cribbling of personal guarantors. So now when both of them are under insolvency and there's a combined insolvency, I think maximization of value could be there. But 13 to notice, there is a rider, you can't use it as an invocation tool. Another difficult task, and this I have been facing, suppose you are a personal guarantor, what is the claim you have to admit? And I've seen, and again, bankers are here, when the claim is filed by the creditors, that is the bankers, they need to give effect to the amount of recovery they have done in the company. It's a coextensive liability. So if the company has recovered something, then that amount will get reduced. But they claim always the complete amount. So that is wrong. So if the debt is 100 rupees, 40 is recovered by resolution plan, only for the balance 60, the personal guarantor is liable. So the deficit in recovery of the corporate debtor will be the claim of the creditor in personal guarantee cases. Yes, sir, please. So that's again a very good question. So when the claim goes to the personal guarantor, it will the claim on that date. There is no provision under the law which stops the interest from accruing. The only thing is, in the CIRP process, it is written that you have to take claims as on the CIRP initiation date. But when the company goes into liquidation, again they are liable for the intermittent period also. So only in the case if there is a resolution, there is some benefit. Otherwise, there is no benefit. Again, this is my personal opinion. Tomorrow a judgment might come having a contradictory view, but today this is what the law is and how it is interpreted. Yes, Jindal sir. So sir, the debt is always there. So interest is liable on the debt, and as and when the amount is recovered, it is always first towards the principal. So whatever is outstanding of the debt of the CD, the personal guarantor is liable. So all the law is remaining the same. There is no change for IBC. The interest will always be there. There is no waiver of interest. Yes, you are right, sir. So there is no waiver, there is no discount, there is no benefit. So see, Section 58 and 59 of Indian Contract Act talks about how you apply the amount recovered. So either the person who is going to pay the amount says that it is towards principal or interest. Otherwise, everything is as per contract. So there is no choice where to apply the money. It will by default go towards principal. So there is no litigation. Whatever is of the CD's debt, PG will be liable. And that's what the Lalit Kumar Jain Supreme Court says. The same thing. It's a coextensive liability. So liability will not reduce. But sir, practically speaking, Anil Ambani has a debt of 90,000 crores. Total group, ADAG group, approximately. And then when Mr. Ambani's PG is invoked, he has assets of only 500 crores. So practically, it doesn't matter.
We are having a presumption that the PG value is more than the CD.
Correct.
Which is theoretically only possible.
Yes. So it's a very good question, and nowadays NCLT has asked the RP of the PG to also inform RP of the CD or liquidator of the CD of the proceeding here, so that he gets an updated claim. So then now it becomes the duty of the RP of the CD to file an appropriate claim or assist in updating the claim. And ultimately, claim is only a best estimate. Whenever you get some recovery, it will automatically get reduced. But now the challenge is on the next part. Suppose the resolution plan is approved and implemented, but there is only 50% payment. What will happen in that case? So That 50% recovery will only be there, otherwise it is counted for both. So this is somewhat internationally, and I think maybe somebody who has seen US, UK jurisdiction, concept of that double dip is not there in India. So if you have recovered from one place, you can't claim it other, but in India it's just the reverse. So whatever is deficit, they will automatically recover from the second party. And that's how it works. Now, another issue which is coming is, suppose the personal guarantor is the managing director. He has signed the balance sheet. CD goes into insolvency. Insolvency is going on, let's say, for 3 years, 4 years. Liquidation is also there. Now, the personal guarantor insolvency banks want to invoke. Can they do it? They have not done it in the 3 years. So whether the balance sheet which is signed by that managing director of the company can be treated as an acknowledgement of debt in his personal capacity. Any views? So it can be treated. Because the concept is, you should know, the concept of guarantor, concept of surety under Indian Contract Act says that the person should be aware. So if you are signing the balance sheet, you can't say that I don't know about my liability in my personal capacity, because you yourself are certifying the debt in the balance sheet. So that defense is gone. And Supreme Court has confirmed that once the balance sheet acknowledges our debt, it's a debt deemed to be in knowledge of the person signing. If the guarantor is a third party who is not a director in the company, let's say not a shareholder, then probably that defense can come in, that he is not aware. But the person who is signing cannot take that defense. So now our balance sheet has a sacrosanct value. Whenever the acknowledgement is there, then the bank has to prove, if 3 years has gone, that he was in the knowledge. Because even now the OTS which is given is deemed to be in knowledge. So Supreme Court has said that even if the OTS are exchanged, you are in knowledge. So all these issues can be there. What I am saying is, he should be in knowledge. Bank should be able to prove to the court that the person against whom they are filing insolvency, in his knowledge it was there was an acknowledgement, and 3 years is there. So normally what happens, and since I am advising banks, so I know, normally banks will always file an OA under RDDB Act, so that those proceedings are always there. Whether they win or lose in SARFAESI, whether there is a delay in auctioning in the SARFAESI, RDDB law is always there. So therefore, now the next point, recovery certificate, if it is issued by the DRT under RDDB Act, that gives a fresh lease of life to limitation, and it is now 12 years. So Recovery Certificate Limitation Act says it is 12 years. So again, there is a lease of life to the personal guarantor cases. And this is recently being decided by Supreme Court in Totem Podi matter. So you can refer that judgment. I have not quoted the judgment here, but now, in case of recovery certificate, 12 years from the date of recovery certificate. Yes. And same for CD also. CIRP can also be initiated in the next 12 years. So most of the cases which got time barred can again come in time limitation because of this judgment. Normally what happens is, after OA order is done, then there are recovery proceedings before RO. So this is referring to those recovery proceedings where you get a recovery certificate. Whenever it is issued from 12 years. Simple. The date and 12 years. 12 years is a good amount of time. Everything is covered. I don't think there is any escape. And probably that is the reason why erstwhile promoters of SR have also settled. Possibly that is the reason. Now, one guarantor, and I am telling you live case, he is also a karta in an HUF. He is also a partner in a partnership firm. He is also running a proprietorship firm. He is also having a company which is listed and he's a director, he's a trustee in a trust. All these things. It's normal, very normal. Now you invoke personal insolvency of this person. What will happen to the partnership firm, to the HUF, to the trust, and to the listed company? So let us take first company, a private limited company and a listed public company. Let's first discuss about the directorship. Nothing will happen to the directorship? Can't be a director. But Vinod sir is saying he can be a director. So this is the section 164, which says he can't be director and he will be disqualified to be a director. He will be disqualified. And the reason is an insolvent person. If you remember our Indian Contract Act, we used to read in the CA Foundation and somebody from P1. Section 11 Indian Contract Act says 3 people cannot do contract. Who are these 3 people? Idiot, a drunkard, and this is the 4th one. So that's idiot. Drunkard, idiot, and so, yes. So now the words which are interpreted are undischarged insolvent has applied to be adjudicated as an insolvent. Both have been interpreted by Supreme Court in the erstwhile Provincial Insolvency Act, and thereby they have concluded that that is insolvent. So once the application is filed, he has filed for being adjudicated as an insolvent, or if there is already an order. So section 100, there is no dispute. Filing of application, yes, if he himself has filed, he is insolvent. To be adjudicated as insolvent by the court. But probably a banker who has filed, that person can be an insolvent or not, yes, that's a gray area. That has not been decided till date. But my view is, once he is an insolvent, he can't continue, he can't get into any contracts, he can't take any decisions. So that's how probably the rearrangement of directorship will have to be done. That's number 1. Number 2 is the shareholding, as you rightly said. Those shareholding cannot be now transferred without RP's knowledge or without putting it before the COC, or the word used is MOC. Yes, sir. Yes, Suresh, sir. Technically, he becomes disqualified. His office stands vacated. So resignation is defined differently, and vacating the office by disqualification is defined differently under the Act.
Yeah, but because the word "and" is there, not "or" is there, so I thought,
Yes.
if he self-files an insolvency application, that's it, he's out. He
Out.
cannot sign any contract. He cannot enter into any contract, you mean?
No, I don't mean, my interpretation is that Indian Contract Act prohibits him from getting into any
The
contracts.
problem is today, many people file the application, it might have been taken up, listed or not. See, many people enter into contract with him, business contract happen, then everything will go for a toss.
Yes,
If,
sir.
This is the interpretation.
So that is,
court
yes,
takes upon.
yes. And therefore, and a very right question came to me from one of the RPs was that, sir, from the date of filing of application till actual admission, the intermittent period, whether he will be able to do business or not. And my suggestion is he can't do it. Because if he do it, then probably some assets or some liability will be created, which tomorrow might be termed as avoidance transaction. We don't know.
But again, I think in Kerala court, they have given time period between the date of filing, date of numbering, there is a gap, whether that should be considered.
Yeah,
for
so
intermittent
that
or
the
not.
Kerala High Court judgment says that the date of filing and actual numbering of the application,
Yeah,
only for that limited period. So according to the,
Actually, in practical cases, sometimes there is a 1 year gap between those two people.
so,
play
so,
around with that.
so instructions have been issued by the NCLT president. Within 30 days, it has to be numbered or dismissed.
Okay.
So now they cannot keep it hanging for 1 year and 2 years. So probably that will go out now.
Okay.
After this judgment only, they have issued instructions. Again, I am privy to those instructions. Maybe it's not in public domain, but I am aware. Sir, it will come, but I am saying there is no judgment today. Yes.
So once moratorium applies, that means he is eligible for getting protection.
Yes.
So that protection is available only to the because he is insolvent. But RP gets appointed immediately after filing the application. So that in for all practical purposes he become undischarged insolvent.
Yes, sir, you are right. There is no quarrel to it, but I am saying there is no judgment to it.
I understand. It's all,
I agree with your interpretation, sir.
Right.
So if a person is a partner in a partnership firm, and I think Nagori ji is there, yes, Chirag Bhai is there, yes. So Chirag Bhai was appointed and we were discussing, he is RP of a partnership firm. A person who is an RP of an individual, so let me put it brick by brick, Mr. X is a partner in a partnership firm, he becomes insolvent. Suppose partnership firm has two partners, X and Y. One becomes insolvent and one is solvent. Theoretically, now according to me, section 34 triggers. So if one is insolvent, the firm has to be dissolved because the statutory limit is going away. Suppose there are three partners, two are solvent, one is insolvent. This act says it should be either dissolved or they should take into consideration that cutoff date and reconstitute. That's how it should be. Now the problem is whether partnership firm can be dissolved or declared insolvent under IBC. Answer is no. So Partnership Act has their own procedure. There is civil code to it. You have to do all accounting, do the balances, get an amount, maybe positive or negative, and that claim has to go from partnership firm to that RP of PG. Legal has, he is not getting off, sir. He is live. PG is alive. Legal hair comes when he is not there. And another challenge, I hope partnership firm is clear, no? Another challenge which is coming, and for all the PGs which we have been drilling to understand, these are all excluded assets. And there are personal assets, there are domestic assets, then there is insurance, then there are ornaments. I've already discussed ornaments. They are more precious to females than to males, except Bappi ji. Personal assets. What are those personal assets? The assets which we require to do a living, to do employment, business and all. It includes books, vehicles, tools. I can understand an advocate or a chartered accountant becoming an insolvent. Our whole library is saved because it is excluded. Correct? I can exclude my books. So I will buy books, exclude them, get a discharge order, and then encash my books again. Pardon? So unencumbered, sir, nobody mortgages a book. No pledge, no lien, nothing. So that was on a lighter side. Domestic needs. Again, this is very theoretical and I am still struggling to get any answer. They say unencumbered furniture, household equipment, and basic domestic needs of bankrupt and immediate family. So domestic needs could be that you are wanting those cooking vessels. I don't know whether they will include car or not, mobile or not, that's still unanswered. But probably when you are asking the list, please ask the list of excluded asset. Very important. It is a mandatory requirement of repayment plan. And I have seen cases where our RPs are not asking. You have to specifically ask about excluded asset. Then, interestingly, one of the case we saw, the whole corpus which the PG had, he knew that I am going to get admitted under insolvency, he puts complete money into LIC. So that's an excluded asset. So life insurance policy, pension policy plan, all these are excluded. I don't know how we will come out of this, whether avoidance transaction will apply or not. But yes, we don't know whether we will be requiring to make the insurance company as a respondent and get the reversal done. But this is the issue. There is no limit to it. Limit is only in ornaments, that's 1 lakh. Yes. So one of the case I just saw, the complete money he bought insurance policy.
He can, like we discussed, he can transfer the money to his wife and then they can have a settlement, family settlement.
Sir, that's coming, sir, that's coming. Yes, sir. I am not sure. Neither it is defined. So I am saying whether these vehicles will include my car or my two-wheeler, or these equipments will include my mobile phone, my laptop. I don't know. But I am just giving you some food for thought. Probably they will come out with some list. Because if they go by the living standard or lifestyle, so somebody only has a car fleet, I don't know what will happen. A person like me will only have books. So I don't know. Yes, sir? Yes. And immediate family is also there, sir. The word immediate family is also there. So probably you are only talking about one wife, right? You got my point? No, you can have more than one legal wife. In India, law permits it, sir. Yes. I will come on to your query a little bit later, 2 slides after this. But legally you are permitted in India. And also pension policy plan. Correct, sir. So there is no clarity here, sir. How to differentiate it, it's a big challenge.
Of course, that challenge is there, but basic, there has to be some way of interpreting it. So my belief is that both has to be separated somehow. How will happen, I don't know.
So this is something which might help you. Unencumbered single dwelling unit. So they say that one property is excluded, where you live, you stay, and according to them, you require only a property worth 20 lakhs if you are in Ahmedabad, in some village maybe 10 lakhs. Now the problem is, if you are living in a residential unit where there are 2 owners, one legally wedded wife and you, then and the insolvency was only of one. How to differentiate this 10-20 lakh is a very big challenge. Now suppose there are 5 people in the family. All 5 have given personal guarantee. All 5 are under insolvency. So the question came, sir, can we multiply this 20 lakh into 5, make it 1 crore and get an exclusion? So yes, probably you can get it because ultimately it's quantification. But what will happen in a case where more than one spouse, legally divorced spouse or a separated spouse, and there is an order of maintenance by a civil court to give her a home? So probably in those cases, these assets would be under litigation or dispute. I will come on to the, sir, excluded debt. That will clear your point. This is all about individual only. When there is an immediate family, you are talking about your dependent family, your wife, maybe one or more, spouse. It could be not a wife also, it could be a spouse also. That also I will come on. And also, if there is a court order that this much money you have to give as an alimony, this much money you have to give as a maintenance. So I will come on to those issues. But just first let me go through the broader things, then we will discuss, because I have made some issues also in the end of the presentation, and I don't want to eat up the time of Durgesh Bhai. Personal ornaments, I told you 1 lakh. Now, there is no exclusion as far as IBC is concerned with regard to Stridhan. But in various parts of the country, Stridhan is defined separately. Like I was just researching, I found that in Mitaksha, and there is a Supreme Court ruling on this, with regard to Stridhan, it cannot be used for encumbrance. And that is something which is pin money for the females. And in one school of thought, you need a permission of husband to sell it or mortgage it. And in one school of thought, you require permission of your father. So that's also something which is excluded. It depends on, and broadly these categories are, how you obtained that ornaments. Is it, or this is ancestral from father or from husband? It could be your own ornaments also, from your own money, and it could be ancestral. So that bifurcation might be required. Then marital status, I just told you about divorce, separated, unmarried, and all these status are in your form when you are filing for personal insolvency. If you see that form, these all wordings are there. Now, I was always wondering when I was going and filling the form of a bank account opening, why I have to declare my marital status? But now I understand the reason. Why they require the determination of marital status? Because of this. Yes, sir. Yes. So they say that Stridhan is basically excluded. And that is a protection to the Stridhan or the pin money, which they call it. But again, under IBC, we have nothing like this.
Yeah, but is there any definition of Stridhan somewhere?
Haan, sir. This Stridhan is explained in Supreme Court. I'll give you the 2 rulings. One is Raj ruling, in which Stridhan is explained, and there are school of thoughts and source of, and this is all taken from judgments.
I understand.
So I'm just going on quicker, because otherwise we will not be able to complete. So this is an excluded debt, and probably this will answer your question. One is that liability to pay fine imposed by any court is an excluded debt. One is liability to pay damages is excluded. Liability to pay maintenance under any law is excluded, and liability in relation to student loan is excluded. So there are 4 exclusions under IBC. What does this mean? You will not be exempted for these 4 liabilities. You, even if you get a discharge order, you will still be liable for all these 4. Now what does this mean? So Bansal sir, if you are following Hindu religion and there is an order of maintenance under Hindu law, if there is any other religion, then protection of women law, or maybe maintenance law, any law by which there is a court order to give some maintenance, that has to be specifically excluded, that cannot be included, that cannot even form the part of your bankruptcy estate, that cannot form part of the assets for repayment plan. And this is again a food for thought, and Batraji also told in the morning that suppose there is an oil spillage, and probably he was giving the example of BP, British Petroleum, and there was an oil spillage by the ship on the ocean, and to get away from the liability, they filed for bankruptcy, and when there was pressure, they withdrew it and gave some damages. Here the point is it is excluded. If you see, the statutory obligation to pay damages is excluded. So I cannot do an environmental pollution get a crores of damages order, and then file for insolvency and get out. The basic idea is to protect. But if you read the other three clauses, they are very difficult. They say statutory, contractual, or legal. I don't know what is left. Because even if a financial contract is breached, it's a breach. It's a contractual breach. So I don't know how this will be interpreted, but this is something which is excluded. Again, in your repayment plan, you have to mention what is excluded debt. It's a mandatory thing. And now some suggestions from my side. Once you become the RP of a PG, and I know PGs don't cooperate, and they will not cooperate. The first thing you should do is write to their jurisdictional income tax commissioner and get an access of all the income tax returns. Because in income tax return, you will at least get something to start with. If he is under audit, he or she, then you will get the details of assets also. Second is get a CIBIL report from the lenders so that you get an idea from which they have taken loan, from which entity. Because you mind it, a guarantor does not require under the law to make books of accounts. Assuming he is not under audit, he is not required to maintain books of accounts. So the only way is you get a CIBIL inquiry, you come to know that, oh, these many loans are there. So that's a way. And banks, and I have seen cases, and I think some RPs are not here, but some cases where the banks do not have the KYC. See, if you have a KYC, and the RBI says in every 3 years, once you need KYC, you will have all the data. What are the assets, what is the gold, what is the status, everything is there in the KYC. So there is a RBI master circular on KYC. So under that circular, it is mandated to the banks. If you get that data, your half work is done. Otherwise, you will have nothing to start with. And I have seen RPs taking a view that if I am appointed and if he does not give a repayment plan, what I will do is I will file for bankruptcy maybe after 120 days. Some people are taking the view that after 30 days, if he doesn't give, then I have to go and take an extension. But again, this is all subject to evolve. There is no clear-cut expiry that you go for bankruptcy. But for bankruptcy, there has to be a specific order of bankruptcy and an application moved by the creditors for bankruptcy. We have Ravindraji here, who got discharged during the insolvency process, not appointed as bankruptcy trustee, because the bankruptcy was not resolved. There was no resolution for bankruptcy. So that is also possible that you become an insolvency professional only for that 120 days.
Yeah, but what I understand, Nikunji, is the personal insolvency and the personal bankruptcy. These are two independent processes.
Yes, so by default, you will not go into bankruptcy.
Yes.
That's the point which I want to make, because there is a presumption and a myth that automatically it will go to
No,
bankruptcy.
because in CRP, and this is a major difference. These two.
Then there is no Form H. When we file a repayment plan, there is no Form H. So what we have done in the plans which we got approved is that we got regulation by regulation compliance. We just read the regulation and did the compliance and made a chart, because there is nothing called Form H in personal insolvency. So probably it's similar, term of the plan, what will be the breach, how many days, if delay is there, we will take interest, modification, monitoring committee, all those things which we put in resolution plan. Repayment plan, when you are making, you should know what is the outstanding claim of the creditors qua CD. So I need to have the CD's resolution plan and CD's recovery status when I am RP of the PG. So being an RP of the PG, I should have all the knowledge what is happening of the CD. So the RP of the CD has to cooperate to give data. If he does not cooperate, I will have to go to court. So that's very important, that he should share the status of recovery, what were the terms, and whether there is a breach in the repayment plan, and the resolution plan will run concurrently. It will happen in the case where there is an MSME and 29A is relaxed. Same promoter giving a resolution plan will also probably have to pay something in repayment plan. Otherwise, they both don't get resolved concurrently. No. He should. Yes. And that is there in 29A also. If you read 29A, I think it is clause H, which debars you, if it is invoked. If not invoked, done, and then they have started, then again you have to shell out some more money. Because if the PG's insolvency application is filed, even then he cannot give a plan, because then there is a moratorium on the disposing of the assets. So if he wants to pay something, it's disposing assets, so it can't be done. So this was a case where we got extension beyond 120 days, again of NCLT Ahmedabad. And in the same case, we got a common repayment plan approved of all the 5 personal guarantors. Just for usage, you just want to refer for ready reference. I think, yes, 2 or 3 things are left. One is passport deposition. So if the person is outside India, and he is a personal guarantor and there is an insolvency, I heard somebody saying in the court that, sir, my guarantor is in US, so he will take some time. Sir, your first thing is to stop him from going outside India. He's insolvent. So that passport should be deposited with the NCLT, and there have been cases where even otherwise under CIRP, courts have ordered to deposit the passport. So this should be the first thing. If the person is having a flight risk, please make sure that he deposits the passport with the NCLT. He will never deposit with you. It is better to get it deposited in the NCLT. And it is now confirmed by NCLT and NCLAT that passport deposition can be done by the NCLT. That depends on you, sir. When non-cooperation starts, then only you will move an application. I am saying this is for RPs. When RP is there, only then he can move an application, no? This is for RP to get it deposited, not PG. Why will PG go and deposit? It will be for the RP only. Check bouncing cases. So now we have some precedent that all the check bouncing cases also being quasi-criminal, if they file a claim, the proceeding will be stayed, and ultimately it will get zeroed. As of now, no, because Pritpal Singh judgment is there. Let us see if it is getting reversed by Supreme Court, then we don't know. But as of now, the law is this. PUFE, I think sir will take. So sir, this is a question for your deliberation also. If there is a PUFE application against the promoters, and now under personal insolvency, promoters are enjoying moratorium, whether that action against the promoters can continue in NCLT, because the law says no legal suits, qua debt. And NCLT is not a criminal code, it's qua debt only. So this is something probably Durgesh Bhai will throw some light. Second is, if there is possibility of PUFE transaction during insolvency process. So under insolvency process, I did not find any section where PUFE can be done by the RP. PUFE transactions could only be identified in the bankruptcy section. So that's again my observation. But in our case, lenders are saying, please do PUFE in insolvency process also. I don't know how to do it, because there is no provision under the law to do it for PGs. So this is again a question which probably Durgesh Bhai could answer. Custody of assets. Under insolvency chapter, for PGs, there is no provision that custody of assets will have to be taken by the RP. So I gave you the example that the RP goes to the house of the personal guarantor, tell him to declare the jewelry, and he says, sorry, you can't do it. There is no provision. So he can't take custody of the assets. At the best, he can ask for it. Sir, your case I have referred Ravindraji. So it doesn't go into bankruptcy. Personal. Yes. They can only terminate the insolvency process, can't trigger bankruptcy. And personal guarantors, if majority decides to waive it, now it is confirmed by NCLT, NCLAT, and Supreme Court in Ujas matter, where I only appeared, that personal guarantee is waived by majority of COC members. It's binding on all. So if you are able to get a good bargain in COC, probably PG will not start. That's all from my side. Any queries I can take, otherwise I will hand it over to Durgesh bhai. Sunit sir, should I take queries or we take queries together? Okay, 2 queries Sunit bhai is saying. Yes ma'am, please, last one.
His discharge of guarantee in his repayment
No.
plan?
Ultimately, it's a coextensive liability. So if there is a guarantor 1, guarantor 2, guarantor 3, until the bank gets the money, the creditor gets money, he will continue to do personal insolvency against all the guarantors. So
Okay,
if one gets ended in bankruptcy, it doesn't change the status of others. Only if the money gets recovered from guarantor 1, then they don't have a right to go against 2 and 3.
Okay. So nobody can like ask for discharge of guarantee on behalf of any other guarantor, right?
You are asking for discharge of guarantee?
Yes, yes. If say for example Mr. X is he has not submitted the repayment plan and bankruptcy application is filed against him, and now his, say for example, his family member, his son or his father, he is submitting a repayment plan and asking for discharge of guarantee, his guarantee as well as the relatives.
That can be done. That can be done. Why you want to give repayment plan then?
Resolution.
You can settle the debt, no? There is a withdrawal provision here also. Just like we have 12A, here also you can withdraw the application. Get it withdrawal at any point. But the only provision is, again, 90% COC should agree. That's the basic thing. Sir, one moment, let us take him. Yes, sir, please. Yes. Sir, guarantees are of 2 kinds. One is blanketly for the money which is lended to the CD. One is restricted to an amount or to a property.
Amount to the extent of the whatever the amount.
So that, yes.
But in case of the asset sold by the banks, that amount will be not up to the marks. What is the valuation done by the
That
bank?
guarantor stands discharged if it is an amount-based guarantee.
Okay.
If it is an amount-based, it gets discharged. Yes, sir. Anclet said so, though I don't agree with it, but yes, I am echoing what Anclet has said. They say that 13.2 is only for those assets which are secured, and for enforcing the security interest of those assets, it is informed. They say there should be a separate notice for invocation of guarantee. No. Every law says that if I am invoking a guarantee, I will have to put some clause of guarantee and invoke, give a notice that you pay. I am recalling the money from you. If you don't pay, I will start proceeding. See, in OA, whenever OA is filed in a DRT, under RDTB Act, we always invoke. Ultimately, we invoke the guarantee only. So that's how it is done. And again, my view is, and probably I don't know what Supreme Court will say, but my view is when Supreme Court has said that recovery certificate, you get a 12-year lease of life. So it means that today they said that it is time barred because of 3 years. Tomorrow recovery certificate comes under RDTB Act, and again lease of life is given to the same financial creditor. So there is some disconnect. There should be procedure that if that is there, it should be considered as in limitation. Because once somebody comes under IBC, 238 helps and everything goes away. But if that continues, this is also there, no purpose is achieved.
Connected with this, I mean, not exactly 13.2 notice, regarding that letter of invocation is the basis for starting the process. I think there is some Supreme
Yeah, but
Court
that is
judgment.
all related to RDTB Act, nothing related to insolvency. I tried finding it, but I couldn't find anything. That is the only guidance we have till date. In fact, in one of the matters, the suspended management was one of the member he was an MLA. So when he knew that because of this PG, he becomes disqualified under Representation of People Act, next day he paid the full money. He did not pay money during the CIRP of CD. It went into liquidation. But when it came to his personal insolvency, he paid the money. So that's how the law is. So, yes, sir. I think last question.
Bankers can go for PG.
Yes.
Now, when there is no resolution plan, how the PG matter will be handled with respect to debt of
Total
the
debt. Debt will keep on updating.
period of time, it will be a total debt of the company, even if the CIRP is going on.
Until there is no recovery, there is no updation of the claim.
And it is the choice of the bankers to decide whom will be okay.
Now, since you have asked this question, because it's a very detailed question, see, Guarantor 1 is admitted in January. Guarantor 2 is admitted in Feb. Guarantor 3 admitted in March. And the CD is admitted in April. So technically, the procedure should be, all guarantors and CD should be admitted together, or they should be started but end together. Here the mismatch is 120 days, they are 180 days. One getting triggered today, another getting triggered tomorrow, so we don't know how the claims will get updated. The law says claims will get updated. If there is a recovery, then claim will reduce. They keep on reducing. Thank you very much for a patient hearing.
Wonderful deliberation and interactive session. Let's have a big round of applause for Nipun sir. I think it's a very crucial area because there are so much uncertainty in this area. It looks like a small area when we compare with the CIRP of the corporate debtor, but actually it's a crucial area because of uncertainty. Thank you so much, sir. Now I would request Durgesh Pandey sir to come forward and give his insightful knowledge with the topic of effects of avoidance transaction. Please, sir.
A very good evening to all of you. It's not very often that I start speaking at 6, and I understand your impatience. I'm told I should restrict it within time. I believe restricting it within time. And I'm lucky that I have somebody, helping me as good as Nipun Bhai. He's doing my presentation. Thank you. Thank you. Yes. So, okay. So, I have around 10, 12 slides. We have, first of all, a caveat. Looking at the sections and the debate around the law, I'm not a qualified RP. I am not a lawyer. My understanding of law is very restricted. My understanding of insolvency law is more restricted. So please pardon and excuse me if I falter. Yes. Very quickly, we are discussing the PUFE transactions. As I was told, we'll be discussing the PUFE transaction with a little bit of focus on the personal guarantors and the bankruptcy cases. So the emergence of PUFE transaction is because of the waterfall mechanism. The waterfall mechanism is a sacrosanct mechanism given in the Act. It should be followed not just in letter, but in spirit. When we have to explain this waterfall mechanism or the PUFE transaction in a class of novice, of course, this is a very elite and educated audience, but the simple way to explain is A is to be paid first, then B is to be paid, then C is to be paid, then D is to be paid. That is the waterfall mechanism. If any of them is paid before when they are supposed to be paid, then it is breach, either in letter or in spirit. So this is the basis of the PUFE transaction. Now, I'll not be discussing these sections because these are very well known to all of us, 43, 45, 49, 50, and 66. These cover the entire gamut of PUFE transaction. In fact, because the time is short, otherwise, I very recently, we were appointed on a case where we were appointed by EOW, Economic Offence Wing, Gujarat State. It was a unique type of fraud abusing the entire process of IBC, where the RP, the CD, I mean, there was no bank involved. But it was wonderful. If we'll have time, after this we'll discuss. These are some cases, I mean, which Nipun Bhai was discussing. PGIRP can be directly initiated even without initiating CIRP. This is very well understood. We know that in Omkara ARC cases. See, liability of PG and CD is coextensive, as Section 128 of the Contract Act we have. Though there is a feeling that once the CIRP is done and the debt is discharged, the personal guarantor should be absolved from the liability, because if the principal debtor under the Contract Act, if the principal debtor is absolved from the liability, you cannot have the surety still responsible for the liability. That is a stand taken. But there is ample clarity on that, because the principal debtor is discharged from the liability not because of payment, but because of operation of law. Ultimately, the banker has still not received what they are supposed to receive, or the financial creditors, they have still not received what they are supposed to receive. Now, how do you recover post-to resolution? So, whatever I understood, whatever I read, because it's still evolving. If we have someone, a legal luminary like Nipun Bhai, who's telling that the law is evolving, and we still don't have a lot of precedents to discuss on this, I really don't know how authoritatively I can quote the sections in the cases. Nevertheless, whatever I have understood, whatever research I have done, I understand that the resolution application should be clear and specific about the recovery from the personal guarantors for the PUFE transaction, even after the acceptance of the resolution plan. So yes, there is a probability that money can be recovered by the bankers after the resolution application is accepted. But this can only be possible if the resolution plan has this clause in it. Only then it is possible. Now, practically there will be so many challenges. Practically there will be so many challenges which we cannot even imagine had the lawmakers imagined that they would have taken adequate care to put in. But in a presentation of 30 minutes, we have noticed that there are more questions than answers. So we have to wait for the time when this evolves. Now, the purpose of invoking both is there. If a bankruptcy petition is filed and a PGIRP insolvency is filed against the same person by two different agencies, then I understand how will the moratorium play out. That is still to be seen, because there will be moratorium. At the same time, somebody will be asking for his or her debt. And mind you, the PUFE transaction, in case of companies itself, we are facing this challenge. We are not able to investigate and we are not able to get information. In fact, we are doing a PUFE transaction. We are doing a transaction audit for Sunit Bhai. I really don't know what is the report that I'll be giving him. He has asked me several times. I have told him कि 10 पेज लिख सकूं उतना तो data मिले, वो भी नहीं मिल रहा है. क्या लिख के देंगे? And why I'm telling this is because the moment we go for personal bankruptcy, for individual bankruptcy, and for partnership firms, the data is not organized. And all transaction auditors, they have to barge on the gray area of personal rights. How are we going to get the data? How are we going to get the information? And this is my fight with the bankers when we are appointed as investigators on behalf of the bankers. See, as of now, there's no act, rule, section under which the investigative audit is appointed. Of course, for transaction audit, we do have section for appointment, but then all appointments before the insolvency process, when the banker appoints, that stems only from the Contract Act. And we are the agents of the bank. We act in principal agent capacity and we investigate in capacity of the agent. Now, a principal can devolve only those rights which he has. So, if the principal himself is or herself is not having that right of calling for records, asking for bank statements from different banks, asking for property details from the sub-registrar, how do you expect the transaction auditor to be doing that? I mean, some sort of regulation has to come in. Nipun bhai, you are well connected. Please try to bring something so which makes our life easier and good recovery for the bankers. I remember delivering a session for State Bank of India where the directors, independent directors of State Bank of India were there, and then very candidly he said कि ये कोर्ट कचहरी पुलिस थाना तो ठीक है, हम तो बनिया हैं, हमको इंटरेस्ट है अपना पैसा रिकवर करने में, पहले मिल जाए तो ब्याज, ना मिले तो मूल तो सही, इतना तो मिलना ही चाहिए. We are really not keen on fighting and getting into the legal process. So, we don't have the clawback mechanism in this. Now, you know, the frauds, or rather the transaction audits in this section that we have under play, they follow two things. One is, there's an actual fraud, which can be covered by 66 and 49. Or there can be a constructive fraud. Actual fraud is still, I mean, that can be proved to some extent. But constructive fraud, it's mostly a difference of opinion because you have multiple stakeholders in case of constructive fraud. Now, what do we call constructive fraud? I say that my laptop is for 5 lakh rupees and then somebody has sold it for 2 lakh rupees or 50,000 rupees, then this will become a undervalued transaction. This is perception of interpretation, the conundrum of interpretation. This comes under constructive fraud. Whereas, if it is sold, it is not disclosed, then this comes as actual fraud. Now, I have tried to put a list which I have called as badges of fraud. These are the indicators and badges of fraud, and then if you bring this with some sort of evidence in the court of law, probably you will be in a very strong position to prove that fraud has happened. These are some badges of actual fraud. Transfer or obligation was to an insider. This is related party transaction. Corporate debtor or personal guarantor retained possession or control of the property transferred after the transfer. So, still the possession is there with the person, despite him or her transferring the asset. Transfer or obligation was concealed. The transfer was not known. Transfer was substantially all the debtor's asset. Most of the asset of the debtors were transferred. And some very basic, CD absconded, CD removed concealed asset, CD was insolvent or he became insolvent because of the transfer of such assets, transfer substantially before the debt was declared, or transfer immediately after the debt was declared. These are some badges which you can see on the screen. These are some indicators which, if proved conclusively, they are very well accepted by the courts. We have certain badges of constructive fraud. Now again, as I told, the actual fraud are relatively easy, but the constructive fraud is very difficult because this involves multiple stakeholders, lawyers, accountant, valuers. So it becomes very difficult because of the multiplicity of the actors to that particular transaction. In most of the cases that we have investigated, we have noticed, we have given reports where complaints have been filed with SFIO as well. But then, in most of the financial crime cases, not just in insolvency, but in most of the financial crime cases, the evidences are only circumstantial. In India, we still don't have that corporate culture, unlike the US or unlike the Western country, where conversations are made on emails. Even such conversations are made on emails. We don't have that. So that is why most of the evidences that we discover in our investigation, they are all constructive. Now, if the evidence is constructive, we have to have multiple evidences which corroborate each other to bring out a case. And my experience, at least in the financial crime landscape, says that in most of the cases, once it is admitted in insolvency, फिर तो क्या है, फिर तो कोई option नहीं है. But it's like an arrow which has been shot. You cannot take it back. But in most of the cases of economic crime, it is mostly a sort of extortion, putting pressure. पुलिस का complain करो, दो जने आ जाएंगे, दो constable आ जाएंगे, तो भी पैसा मिल जाता है. It is that pressure and it is that fear which brings the money out. So this, we have some list or some badges for constructive frauds. CD has unreasonably small capital for the business. CD intended to incur or believed it will incur debts beyond its ability to pay those debts. CD made transfer to an insider under employment contract outside of the ordinary course of business. These badges, once you read, these are pretty evident. Now the conclusion. The drafting of the resolution plan has to be very tactful. If we are expecting to recover money post acceptance of the resolution application, then the drafting has to be very, very tactful, because everything will be followed by the Contract Act. The law, particularly the insolvency law, is still evolving. So the drafting has to be very tactful. Creditor to put clause of recovery from personal guarantor even post resolution. Ideal to initiate, probably he told it a number of times. I would reiterate that it is ideal to either initiate the recovery. He went to the extent that it should conclude at same time, but I understand it should be started at the same time. Time is an essence in investigation. 2 दिन बाद अगर एक आदमी को पकड़ने जाते हैं ना, तो 2 दिन में तो बहुत सारी चीजें खत्म हो सकती हैं. So it is ideal that the proceedings should start simultaneously. Now, as I said, more questions than answers. Multiple litigations due to overlapping of rules. Enforcement of moratorium. What will happen in the moratorium period? PGI moratorium, again bankruptcy. Personal debt and multiplicity of jurisdiction. These are personal debt. There will be multiplicity of jurisdiction. As I told, we were discussing, couple of days ago, we were discussing कि भी content overlap ना हो और आप क्या करोगे भाई, आप धुरंधर हो insolvency में, हमको तो मर्यादित ज्ञान है, तो आप क्या discuss करोगे? I was discussing with him, with Nipun bhai. And then it amuses that if somebody files a case against me for bankruptcy, I can very well give my wife to my wife, and then we can enter into a divorce settlement that I have paid maintenance and my house is my wife's. Cohabitation after marriage is very much permitted. And sir, to answer your question, that you said that 1 legal wife, 2 legal wife. In fact, I was writing 3 days ago, I had a very senior officer from the economic offense wing calling me. There was a dispute of property they don't know how to settle. It belongs to an erstwhile Nawab of a state, where the son of the first wife is fighting with the second son of the third wife. There's a private trust, and the private trust extends into 32, the deed of the private trust extends into 32 pages, drawn in 1941. 32 pages, typed 32 pages, 1941. Mind you, the list of assets starts from page number 16. So पेज नंबर 16 से पेज नंबर 36 तक खाली एसेट्स का लिस्ट है. तो हमारे देश में तो होता है. Anyways, I understand, this is all from my side. We have some very short time. The one case which I was telling, 5 minutes, not more than that. Sunit bhai, 5 minutes? Okay. So the one case which I was telling, I saw a case where, in fact, we are in process of investigating. अभी तो resolution application भी आ गया है. जब से EOW आया तब से RP साहब पीछे हट गए, नहीं तो तब तक तो कर ही रहे थे वो अपनी मनमानी. It so happened that there was a complaint was filed with the Economic Offence Wing, and then they called me. We were appointed on the case. I'll just tell you the facts of the case. It was a cooperative society earlier. Then the cooperative society was converted into a company. Please don't go into the law and the merits, because we are more on the, I understand more on the criminal side of the cases rather than on the procedural side. तो कौन सा miscellaneous application file हुआ कि other application file हुआ, कौन से section में file हुआ, अपने को नहीं मालूम है. ठीक है, हमको तो 416, 420, 468 यही पता चलता है. ठीक है, I am still a chartered accountant. No, seriously, I am still a chartered accountant. That comes to my rescue when I am told to opine on legal matters. Yeah. So I was telling, we had a case where a case was filed that the minority shareholders were not getting anything in the case. Now, as we know, in Surat, we have chitti wala hisab jada, cash-based economy. So most of the money that has been given, that is on cash, and a very small amount is on the books. The property in dispute, the value of the property in dispute has increased about 20 times in crores. Yeah, 20 times. The property has increased 20 times. And now the company has never taken a loan. All of them together, simultaneously, they paid money. There were 20 depositors who paid money to buy the property. So technically, it was like a housing society where everybody paid money to buy a property. Somehow, it was not constructed, and the architect raised a per forma invoice of around 4 crore rupee, per forma invoice again. The case was admitted. Resolution application भी आ गया है. अब हुआ क्या? One of the depositors, a consortium of 10-12 depositors who deposited originally for the company for buying of property. 10-12 depositors were taken who were in accomplice with the directors. They came together. Some documents were forged. What document? Promissory notes were created that the money they gave, those were not for deposits. Because the moment the money was for deposit, they will fall under operational creditors just like all other depositors. Okay. But then promissory notes were made in backdate. So because of that promissory note, these depositors became financial creditors. General purpose loan. They extended general purpose loan. They became financial creditors. And then RP was appointed, and then काम चल रहा है. Now what I understand, the directors, they are supposed to vehemently oppose the CIRP process as to why the company has gone into CIRP process. Now here the directors have encouraged the architect to file the CIRP process. The decision is taken by the RP in consensus with the financial creditors. So the financial creditors are family members of the directors who had given the money, general purpose loan they had given. So, and then the RP is appointed. I don't know, I really can't say whether the RP is in hand in glove with the directors or not. I am no one to opine on that. Now the result of all these things is, I know it may sound complex because I'm not able to explain the names and the facts. सब गुजरात के हैं, बहुत ज़्यादा मैं बोलूँगा तो क्या प्रोफाइलिंग हो जाता, आइडेंटिफाइड हो जाती कौन सी कंपनी है ना, और सब जुदाई से, इसीलिए फिर बात करना उचित नहीं है. Now, what has happened because of this? 5 directors or 10 directors, they are eating away the entire asset which has inflated significantly in the company. Because those poor depositors, most of them who paid cash, they have not even filed their claim forms, because what is the ground for filing the claim forms? And the RP has coolly rejected the claim forms. He is very much at liberty to do so for some technical reasons, and in most of the cases that you don't have an acknowledgement of payment. As to how have you paid, there's no acknowledgement of payment. So the RP has rejected. The case is still progressing as we discuss, but I understand the minority shareholders or the aggrieved shareholders, let me use the word, the aggrieved shareholders, they'll be getting some sort of money, because no, we have not seen any action. I have given the draft report, and we have not seen any action in the past month, a month and a half. It happens in most of the financial crime cases. वो तो क्या रिपोर्ट सब आता है ना, तो दबाव बनता है, प्रेशर बनता है, फिर एक दूसरे को पैसा दे देते तो बात खत्म हो जाता है, ऐसा. So this I have noticed one of the finest case as to how a very nice legal provisions were abused to take the money legally. And I understand still that transaction is pending, because that transaction amongst the aggrieved shareholder and the director, that transaction is still pending, because they are telling that हमारे resolution applicant को अगर जो मिल गया तो जो बोलोगे वो दे देंगे, नहीं तो अमाउंट देखेंगे. अभी वो स्टेज पर मैटर है. Thank you so much. I just have 2 minutes of my scheduled time, so thank you so much for the patient hearing.
Thank you.
Thank you. मेरे ख्याल से अब प्रश्न तो नहीं होना चाहिए, 6:30 बजे, अब तो चाय भी बाहर नहीं मिलेगी, है ना. चलिए, थैंक यू.
थैंक यू सो मच निपुण सर, दुर्गेश सर. सुबह से जब इवेंट स्टार्ट किया तो फर्स्ट फैकल्टी वाज दीनल भाई फ्रॉम अहमदाबाद, एंड एट लास्ट अगेन वी हैव 2 फैकल्टीज फ्रॉम अहमदाबाद. सो द एंटायर जर्नी सीम्स लाइक के सुबह घर से बाहर निकले थे, पूरे दिन बाहर का खाना खाया है, काफ़ी वो डिलीशियस खाना ही था. ऑल द फैकल्टीज वर सो ब्रिलियंट एंड सो एक्सीलेंट, बट एट द एंड ऑफ द डे वी लव टू हैव आवर होम फूड, मम्मी का बनाया हुआ खाना. So listening to them feels like, because we have a wavelength match listening to them since years, so it feels like sir home का घर का खाना खाया ऐसा end किया है sir. Thank you so much for this lovely deliberation. First of all, thank you so much to all the delegates present here who have come from outside. All the local delegates, and we are successfully completing with this conference, one-day conference on insolvency and bankruptcy. Although we have to rush fast, because the things was like that, the whole concept was that we just have we touch upon the points which are going to happen or which are happening, which are innovative ideas that are coming up. We cannot go into detail in any of the topic, any of the subject. Reason being that would get a bit boring. So it's like we touch upon all the new things that are happening into the insolvency space. And if someone is like interested in mediation, so everyone is knowing now that there is something mediation that is coming up after listening to such eminent faculties. So they can join some mediation conferences, typically or particularly dedicated to such conference, such subject, and they can have. So that was the whole idea, that we can have the best of the faculties with the unique topics in a day conference. So we were done with now 18 plus faculties in a day with 6 sessions, highest ever I would say, because every time we try to have the session for restricted to 4 and 5 sessions. So this was the 6th session. Thank you all for cooperating. We ran so fast, but what starts the best ends the best. Thank you so much. Thank you all the event partners to this. And particularly thanks to one name I should not forget, Badri Narayanan, who has supported equivalently. Just raise your hand, or you should stand up for I would say he was assisting me for the branch at least for getting all the things done. Thank you so much. Thank you all the participants for the patient listening. And the elections are around the corner. I request you all to exercise your vote. Thank you so much.